what looks like an adjacent parcel, and the easement comes from a common grantor. The property interest of the adjacent property owner runs to the center line of the easement, and it's applicable to railroad easements, canals, roads, and everything else. By the way, I have a website, www.railroadedalaska.com, and you can read about that in the Asmussen case in Colorado in 2013. I lose a decade, my age.
Okay, so if I might, when you look at your as-built for your property, does it show your property line crossing over, or
No.
are you saying that it just goes to the easement line, and then your claim is that the real estate law split from the center line of the easement is your access and their
And if you have an owned property on both sides, then your interest runs to the center line. And there's also another case, the U.S. Supreme Court case, the Branch Revocable Trust case, you might read that has to do with that too. So it's all on the website. I sort of created this as a dump for information for the people that are into reading into the weeds on the subject. But going back to the resolution at hand, the Assembly did the proper thing, which is to support and maintain the property interests of the municipality of Anchorage in this thing and move it along through the legislature to the congressional delegation. So I agree with the other speakers who have said that this is just a step forward to resolving this issue. So I don't have much more to say about this unless you have other questions. Thank you for your time.
From a methodological perspective, the only resolution that I could see would probably not be one that you would like, because the document would come forward as another resolution. That resolution would say, the Assembly passed a resolution, but you weren't heard. We heard you. The body still agrees with the first resolution. I think that if a resolution were to come forward, that would probably be how it would be written, right? Because already the question has been asked. We would even say that. The question to reconsider was asked and the reconsideration failed. So I think that actually works against your position if that goes forward to the legislature as a second communication. So I don't know if we would want to do that.
I think we gotta discuss it.
No, well, we would. That would be germane in the work, but it seems like that might not be actually in your interest. What do you think?
I think he's talking to the railroad.
Yeah.
He said,
Because they've asked us if we could rescind the action. And, I mean, that's probably not going to happen. The best we could do is say, we had a meeting, we didn't invite you, now we invited you and we heard you, and...
Just a point of order on that is I think technically what Dina said, we lost the opportunity to rescind, which
Right.
has a very specific meaning. So were we to do something different, it would be to have a totally separate ordinance that would do what we think of as rescind, but not using that.
Well, and I don't think that such a thing would pass.
hold on, Mr. Gates.
I guess to clarify, you could do an assembly resolution that says we're rescinding our previous assembly resolution. That wouldn't be the same as saying a motion to rescind something adopted. It would have the same effect, but it would go through the same process as a new law. I guess I would say that you could do that if we want to actually change course and you want to rescind or 2018-94. And then the other way, I think, as Mr. Constance said, we've had this work session, we've heard the railroad, their arguments and position. I think at the next meeting you want to say something at the appropriate place on the agenda on the record that this took place. And that we don't have any resolution to change course. You know, so either way, you want something on the record on April 10th.
Can you remind us of that, Paul, remember?
Well, I mean, practically speaking, any assembly member can put forward a resolution. Only assembly members can put forward resolutions, or I guess the administration through the chair also could. So if the railroad really values that kind of resolution, you need to find an assembly member that's willing to introduce it for you. You know, and that's the answer. And if no one does put forward such a resolution, then we can have the statement on the record. Either way, we can do the statement on the record Mr. Gates suggests.
Tim had his hand up.
I'm sorry, I can't see. Yes.
So I'm Tim Sullivan, I'm also with the railroad. You know, one of the comments that both Mr. Remington and Mr. Dunbar have made about getting this to court as quickly as possible. The idea of HJR 38 is not to get it to court as quickly as possible. It's about sending it to Congress and spending what imaginable time it could be going through the congressional process, which could be years. If the intent of this body is to send it to the courts and encourage it to get to the courts, then the amendment should say, or amendment to the resolution or a new resolution should say that specifically, that you want it to go to court, that you want it to go to court as quickly as possible. That's where this should be decided. What you have supported at this point is not to send it to court, is to send it to Congress to change. That's a big difference. Eventually it'll end up at court, but you haven't said that. And you could encourage either us or them, or both, to get to court. That would be the resolution here. That's what you said you wanted to do. That's what we see as being the best resolution. This needs to get to court. The sooner the better. Sending it to Congress doesn't get it to court anytime soon.
Well, so, but to that point, I mean, you could try to have a resolution that goes through Congress and through the courts simultaneously, right? I mean, these aren't necessarily mutually exclusive. I mean, so another resolution could say, just not mention HJR 30 at all, and just say, how about we also try the court?
You know, point on that, and correct me if I'm wrong, but my understanding in ARDA is that if it goes to court, you guys don't defend it, the Department of Justice does. So it's federal money defending this. So if any individual took it to court, it would be this one individual against the federal government in court.
Is that true?
Probably. There is a guarantee in ARDA, and I think that, you know, this can be looked at both ways. It shows how important this really was to the transfer. There is a provision that says it's pretty specific to this situation of the exclusive use easement, and it says that if any party challenges that the railroad has not less than an exclusive use easement in the right of way, the federal government will step in and defend our title. That's how it's.
This is why we raise it to the highest level.
It's an unusual provision, but I think, you know, that cuts both ways, because I've never seen it in any other federal statute. It's not, and I don't think federal lawyers like having Congress tell them they're going to have to defend something in the future potentially. But that is true. That is in there. And you know,
That doesn't prohibit a class action suit. If you go by the numbers of what Representative Kopp is saying, there's 1,100 people, 1,100 property owners. That seems to be right for some sort of group to get together and file a lawsuit together. But if there aren't, you know, and that's where the opportunity lies to get this to court.
Is there actually the ability to do a class action? I mean, there's a lot of times when you are prohibited from doing class actions. You don't believe this is?
it doesn't, certainly the Railroad Act doesn't speak to that.
Okay. Well, if I see in the future that you guys are arguing that they can't form a class, I'm going to be very upset.
Well, class actions, what I would say is you have to show that you've got enough commonality,
right.
Both of the interests of the parties and of the legal issues. And that's for a court to decide. But so if we were presented, it all depends on how the class was defined and what the claims were. If we were presented with one and we looked at it and said, this doesn't fit into Federal Rules 23, I think it is, to certify a class, I'm not going to sit here and say we would waive that right, but I don't think there's anything in the Railroad Act that says you can't do a class action.
Any of the audience members wish to comment? Yes, Mr. Meacham.
Yes, I think there's a question whether the federal government has waived its, or the state has waived its sovereign immunity. Because under the 11th Amendment, the state cannot be sued in federal court without its consent. The provision in the Transfer Act says that if there's a challenge to the any of the property rights under ARDA that brought against the state or against the feds, then the Attorney General shall step in and defend. But the cases I've read indicate that may not be a clear enough waiver of the 11th Amendment. So it may be that you have an issue that the state courts couldn't hear because deals with federal issues, and the federal courts couldn't hear because the 11th Amendment hasn't been exclusively waived by the state.
Do you have anything to say to that, Mr. Sullivan?
Let's go to court, figure out whether that's the case or not.
Which court?
That's to be determined.
My wife objects to spending our retirement money suing the railroad. I'm speaking for her, and I rarely do that. That I have any folks. this John Fletcher again. I have spoken to several of the individuals involved in the transfer, including Don Young and Dave Walsh, who used to be an assemblyman. And he was Ted Stevens' negotiator on this, and they are appalled, I think, at what the Department of the Interior and the railroad has done here. Don Young has said to us in no uncertain terms that the property rights of individuals that were vested before the transfer were not to have been upset during the transfer or changed. If you get on my website, you'll find an example of the original patents, and you'll find an example of the ARTA transfer patents. And they changed it. They did exactly what Don Young did not want them to do, and others in our delegation. Just saying. So all these legal arguments aside, these people, the railroad and the Department of the Interior, did something that was completely unanticipated by our congressional delegation in 1982.
Mr. Peterson.
Thank you, Mr. Chairman. I used to live in South Anchorage myself for about 20 years, and I heard from numerous neighbors and customers of mine about disagreements they had with the railroad right away. And this issue's been ongoing for a long, long time. And so if we could find the right court that had jurisdiction for this case and come up with a final judgment so everybody knew what the situation was, I think that would be a desired outcome.
Yeah, the gentleman who just sat down, do you wish to testify?
Actually, I think I'm going to pass. I'm too much of an emotional spoke on the wheel here, so I'll probably just put my foot in my mouth and maybe I'll communicate to you individually via email or something so you can understand my sentiment.
Okay.
So I have another question. It's very technical and narrow and not really on the broader question, but back to Mr. Fletcher, you talked about taxes and higher taxation, and I'm drawing my mind around these lines. I do real estate, so I always have to try to figure out how that works. Are you saying that you are taxed for the square footage that's in the right of way, or that you are just assessed because of the value of being on a kind of a rural visual corridor or something? Right, the airstrip there on Ocean View.
I paid more than I would have paid for the square footage of my lot because of the association of the lot with the easement.
But they're not like dividing feet into your square footage that you don't have on your recorded documents.
My assessment of the house is larger than comparable lots say across the street from that easement. Oh, by the way, the railroad is exempt from taxation under the Alaska Railroad Corporation Act.
As are most organizations, it seems, in Alaska right now.
Actually, I do have one. Maybe this would be helpful, but just...
I'm sorry, could you identify
Yeah, my
yourself?
name's
for the
Jack
record?
Brown. I'm in South Anchorage, a property owner. When the RUP permit was rolled out in just South Anchorage, and then the governor's office and Representative Cupp, people stood up and said, well, this is a really bad idea, and then it's since been rescinded. So that was a good thing. That was a good effort that happened. Well, the downside of that is that dumped this whole stinking mess right in the lap of just a few of us in South Anchorage. So this would be like the municipality instituting a new tax on just, one part of the city. And so if you're wondering why there's not a whole flock of people, in here talking about this, that's exactly why. So if that makes sense, maybe that's something that you could weigh in on.
Any thoughts? Okay.
Well,
Yes, sorry, we have one more gentleman in the back there.
I'm Bob Gastrock, and I also am a resident in South Anchorage. I don't want to plow through all of what's already been plowed through, but I would submit that I bought my house there in 1976. And when I did that, that was a portion of the Tom Spearstead homestead. And this question about the concept of centerline presumption and exactly what land do you own and what taxes do you pay on what land you own and all that, I think is kind of confusing. But I think it's important to realize that there are still a lot of property owners, like Tom Spearstead, when he got his patent from the federal government in 1951, I believe, that owned the property on both sides. Homestead patent was for a quarter section of a quarter section. It wasn't a meets and bounds go around, and there was a reservation for a right-of-way through his property. But he owned the property on both sides and underneath with an easement. That's what, when I bought my house, that's what I was buying into. Okay, now I don't happen to own on the other side of the track, somebody else does now, that's another portion of his homestead. But that never went away. And the characterization that to right this wrong is gonna have a negative financial impact on the railroad, I can appreciate that, but that's not my problem. My problem is that my property rights have gone away, and excuse me for the testimony, I don't want to be confrontational, but you've heard the typical dog and pony show here, where we're getting all this, using all of these examples of safety events or non-safety events on the railroad, and I would just, as one example, submit to you the discussion about the two women that were killed back on the East Coast somewhere, that climbed over two gates and fences to get onto the tracks. I submit to you, if they had had an exclusive use back there and had gates and fences up, the people would have gone over them anyway. So the idea that the necessity of having exclusive use to fence off the entire right-of-way from Seward to Fairbanks still is not going to guarantee that somebody won't climb the fence. So I think we're getting the cart in front of the horse on arguments like this. What we need to come back to do is look at the sequence of ownership of the land and the fact that many of us have been wronged by this action. And I would defer to Mr. Meacham's discussion about the provisions of ARDA, for example, that this new term exclusive use, which came to be as part of ARDA, was really not just intended to be, but specifically, if you look at the structure of ARDA, it had to do with Denali and native land claims. Exclusive use had nothing to do with the private owners who had vested rights in lands that the federal government had relinquished all interest in, other than the easement for the train that at that time they operated, period. Whatever land the federal government still owned at the time of ARDA, exclusive use was theirs to give away, but not on my property. That's all I had.
Okay.
Any questions of?
Is there any questions for this gentleman? Okay. Thank you. I think the sides are pretty well laid out right now. I'm predisposed to closing this work session unless someone has something they really need to get out their chest.
Just for the record, say that the recorder never started, so this meeting.
We turned it on at about halfway through, unfortunately.
So, just for the record, we missed a good portion of this discussion, so everybody's, I just want everybody to know, in case you come looking for this record, it will be partial.
Should we go through?
Yeah, let's go around and reintroduce ourselves to the record.
Suzanne McGrath.
John Weddleton.
Christopher Constant.
Forrest Dunbar.
B. Peterson. And Mr. Trainee was here.
Yeah, Dick Trainee was present for much of the time. Could we keep going?
Dean Gates, Assistant Counsel.
Andy Barron, Alaska Railroad.
Brian Lindenwood, Alaska Railroad.
Everybody else who's testified, at least, please.
Tim Sullivan with the Alaska Railroad.
Okay. And in the back?
Bob Jastrock, South Anchorage homeowner.
Matt Brown, South Anchorage homeowner.
Tom Meacham, private attorney.
Thank you.
And just,
Hold on.
And for a portion of the time, Bill O'Leary, the CEO of the Alaska Railroad, also was here.
this was the March 23rd, 2018 work session on AR 2018-94 discussion after the fact of a resolution passed by the Assembly.
Mr. Gates, did you have something to say?
No, it was just kind of mentioned that he was going to add Mr. O'Leary.
Okay. Great. All right. This work session is closed.